General Provisions. Section 230. Money not to be drawn from Treasury unless appropriated, annual publication of accounts, certain revenues usable only for highway purposes. No money shall be drawn from the state treasury, except in pursuance of appropriations made by law. And a regular statement and account of the receipts and expenditures of all public money shall be published annually. No money derived from excise or license taxation relating to gasoline and other motor fuels. And no monies derived from fees, excise or license taxation relating to registration, operation, or use of vehicles on public highways shall be expended for other than the cost of administration, statutory refunds and adjustments, payment of highway obligations, costs for construction, reconstruction, rights-of-way, maintenance and repair of public highways and bridges, and expense of enforcing state traffic and motor vehicle laws. Provisions very similar to the first sentence of Section 230 can be found in the previous constitutions. In 1945, the voters approved an amendment to Section 230 that added the second sentence, which reserves fuel taxes and vehicle taxes and fees for highway purposes. The General Assembly proposed the amendment to bolster the highway fund, which was chronically short of revenue. The Kentucky judiciary has held that the purpose of Section 230 and its predecessors was to prevent the expenditure of the state's money without the consent of the legislature, in Ross v. Gross, 1945. It has also ruled that a court order requiring the state treasurer and commissioner of finance to pay money out of the unappropriated surplus in the general fund to the Department of Welfare to cover an unanticipated cost of living increase does not violate Section 231, in Miller v. Quatermass, 1947. Nor does a legislative grant of authority to the governor to allocate excess funds for designated purposes to state agencies, in Hopkins v. Ford, 1976. In the opinion of the Attorney General, the use of revenue produced by a fee on motor fuels to fund a motor fuels inspection and testing program does not violate Section 230. But a fiscal court did violate the provision when it used money from the county road fund to pay for part of a county judge's salary.
Section 231. Suits against the Commonwealth. The General Assembly may, by law, direct in what manner, and in what court suits may be brought against the Commonwealth. Section 231 contains essentially the same language as sections found in previous constitutions. The Kentucky Court of Appeals held in 1828 that in the absence of a statute directing how suits may be brought against the state cannot be sued in its own courts, an affirmation of the doctrine of sovereign immunity, in Devine v. Harvey. In 1899, the court ruled that Section 231 authorizes the General Assembly to waive sovereign immunity and, by joint resolution, authorize an individual to sue the Commonwealth, in Commonwealth v. Halley, 1899. In 1946, the General Assembly enacted the Board of Claims Act, which established liability for the state for injuries sustained to persons or property because of the negligent design and construction of highways. And in 1950 the statute was amended to provide liability for negligent injuries in general caused by the Commonwealth, or its departments, agencies, agents, or employees. In 1966 the General Assembly extended the liability of the Commonwealth to breaches of contracts. After some inconsistency on the subject, the Kentucky judiciary ruled a city is liable for injuries caused by negligence except in the performance of legislative, judicial, quasi-legislative, or quasi-judicial functions, in Gas Service Company, Inc. v. City of London, 1985, but it continued to maintain the general immunity of counties from liability for injuries caused by negligence, in Cullinan v. Jefferson County, 1967. A metropolitan sewer district is subject to liability as a municipal corporation, in Calvert Investments Incorporated v. Louisville and Jefferson County Metropolitan Sewer District, 1991, but an urban county government is entitled to immunity as a county government, in Hempel v. Lexington-Fayette County Urban County Government. 1982, a corporation created by legislative statute to promote the performing arts in Louisville and Jefferson County is not a department of the state or subject to state governmental control and therefore is not entitled to sovereign immunity, in Kentucky Center for the Arts v. Burns, 1991.
Section 232. Manner of administering oath. The manner of administering an oath or affirmation shall be such as is most consistent with the conscience of the deponent, and shall be esteemed by the General Assembly the most solemn appeal to God. Similar provisions can be found in the previous constitutions. A delegate to the 1890 to 1891 Constitutional Convention summarized well the meaning of Section 232 when he declared that the provision is intended to preserve for everyone the right to affirm rather than take an oath, and that an affirmation should be entitled to the same respect as the most solemn appeal to a deity. A trial judge's statement to a jury panel that it did not have to pay any attention to its oath did not violate Section 232 and constitute a ground for a new trial, in Lanning v. Brown, 1964.
Section 233. General laws of Virginia in force in this state until repealed. All laws which, on the first day of June, 1792, were in force in the state of Virginia, and which are of a general nature and not local to that state, and not repugnant to this Constitution, nor to the laws which have been enacted by the General Assembly of this Commonwealth, shall be in force within this state until they shall be altered or repealed by the General Assembly. Each of the previous constitutions contained a similar provision. Delegates to the Constitutional Convention of 1890 to 1891 defeated a motion to strike out this section. According to one supporter of Section 233, the laws of Virginia constituted the foundation of Kentucky law and represented all law not contained in the Constitution or statutes of the Commonwealth. The Kentucky judiciary has held that because Virginia adopted the common law of England in 1776, Section 233 means that the common law is in force in Kentucky except as it has been modified by the Kentucky Constitution, statutes, judicial decisions and public policy, in Commonwealth v. Donahue, 1933, and that in the absence of statutory law, the Commonwealth may punish wrongs and injuries as defined by the common law, in Nider v. Commonwealth, 1910.
Section 233A. Valid or recognized marriage, legal status of unmarried individuals. Only a marriage between one man and one woman shall be valid or recognized as a marriage in Kentucky. A legal status identical or substantially similar to that of marriage for unmarried individuals shall not be valid or recognized. Section 233A was ratified in 2004 in a ballot measure entitled the Kentucky Marriage Amendment. The measure passed by a margin of 74.6% to 25.4%, despite 2.5 times the campaign spending on the vote no side. On July 1, 2014, Judge John Habron of the United States District Court for the Western District of Kentucky found the amendment violated the Equal Protection Clause of the U.S. Constitution by treating same-sex couples differently than straight couples. On November 6, 2014, the Sixth Circuit Court of Appeals reversed the district court's ruling in Kentucky. In a 2-to-1 vote, Judge Jeffrey Sutton and Judge Deborah Cook upheld the voter-approved ban. However, on June 26, 2015, the United States Supreme Court ruled that same-sex couples have a constitutional right to marriage under the 14th Amendment of the United States Constitution in the case Obergefell v. Hodges. This ruling overturned all voter-approved constitutional bans on same-sex marriage. There have been attempts to repeal this section. In 2016 and 2018, legislation was introduced in the Kentucky House of Representatives, though in both cases it stalled in committee.
Section 234. Residence and place of office of public officers. All civil officers for the state at large shall reside within the state, and all district, county, city or town officers shall reside within their respective districts, counties, cities or towns, and shall keep their offices at such places therein as may be required by law. The second and third constitutions contain similar provisions. The Kentucky judiciary has applied Section 234 to city attorneys in Hurstfield v. Commonwealth, 1934, constables in Ellis v. Wright, 1931, and town trustees in Hill v. Anderson, 1906, but not to special county tax collectors in Commonwealth v. Blackwell, 1895. The Attorney General has applied the section to city police officers, but not to deputy sheriffs or school superintendents.
Section 235. Salaries of public officers not to be changed during term, deductions for neglect. The salaries of public officers shall not be changed during the terms for which they were elected, but it shall be the duty of the General Assembly to regulate, by a general law, in what cases and what deductions shall be made for neglect of official duties. This section shall apply to members of the General Assembly also. The second and third constitutions mandated that the General Assembly should enact a statute that provided for deductions from the salaries of public officers who neglected their duties, but did not prohibit changing salaries of public officials during their terms. The General Assembly first legislated on the subject of deductions for neglect of duty in 1893 and has periodically revised that legislation since that initial date. Section 235 applies to public officials who serve for definite terms and not to officers or public employees who may be discharged at the pleasure of their appointing body, in Commonwealth v. Ewald Iron Company, 1913, or to employees who are not public officers, in Graves County v. Doughty. 1935, statutes that subject salaries of public officials to garnishment or attachment, in Batesville Casket Company v. Fields, 1941, or to a state income tax, in Martin v. Wolford, 1937, do not violate this section. Salaries of constitutional officers may be increased during their terms in an amount equal to the increase in the cost of living, in Commonwealth v. Hesh, 1965. A special court of appeals held that the salaries of the judges of the Court of Appeals could be increased during their terms because Section 235 must be read in light of other provisions of the Constitution, including Section 112, which provides that the judges should receive adequate compensation, and an amendment to Section 246 that raised the maximum compensation for public officials, in Perkins v. Sims, 1961.
Section 236. When officers to enter upon duties. The General Assembly shall, by law, prescribe the time when the several officers authorized or directed by this Constitution to be elected or appointed, shall enter upon the duties of their respective offices, except where the time is fixed by this Constitution. The third Constitution contained a similar provision, which is obviously designed to provide for the inception of official terms of office were not specified in that document. There have been very few published decisions about Section 236. The Kentucky judiciary has held that the section does not apply to members of a county board of education, in Brown v. Rose, 1930, and the failure of applicable officials to qualify within the time specified by the General Assembly or the Constitution vacates the office, in Barnett v. Hart, 1902.
Section 237. Federal office incompatible with state office. No member of Congress, or person holding or exercising an office of trust or profit under the United States, or any of them, or under any foreign power, shall be eligible to hold or exercise any office of trust or profit under this Constitution, or the laws made in pursuance thereof. The first Constitution merely prohibited a member of Congress from serving as governor. The second and third prohibited members of Congress or holders of federal offices of trust and profit from serving in the General Assembly or holding any office of trust and profit under the same. The Kentucky Court of Appeals has declared that the purpose of Section 237 is to prohibit a separation of allegiance from one sovereign to another and to prevent a division of loyalty, in Lasher v. Commonwealth, 1967. Many of the published decisions about this section concern postal workers serving simultaneously in state or local office. Until 1967, the Court of Appeals held that postal workers could not also hold state or local offices. In 1967, however, the court reversed a long line of rulings and held that the position of a mail carrier was not an office of trust or profit under the United States, in Lasher v. Commonwealth, and in 1974 it extended that ruling to a postmaster of a fourth-class post office, in Commonwealth v. Clark. In the opinion of the Attorney General, Section 237 does not prevent a federal employee, as opposed to a federal officer, from also serving as a justice of the peace or a clerk for a member of Congress from running for membership on a county board of education.
Section 238. Discharge of sureties on officers' bonds. The General Assembly shall direct by law how persons who now are, or may hereafter become, sureties for public officers, may be relieved of or discharged from suretyship. Many state and local officials have to post bond to guarantee a faithful performance of their official duties, and as a part of that guarantee need some person or company to guarantee the bond so that in case the official does not faithfully perform his or her duty, and the state on the account suffers a monetary loss that the official is unable to cover, the guarantor or surety will take care of the loss up to the amount of the bond. In accordance with the requirement of Section 238, the General Assembly has enacted a statute that specifies how a surety may be relieved from future liability under this suretyship and to be indemnified for any losses experienced. There have been no published decisions concerning this section. The Special Commission on Constitutional Review of 1987 recommended the repeal of Section 238.
Section 239. Disqualification from office for presenting or accepting challenge to duel, further punishment. Any person who shall, after the adoption of this Constitution, either directly or indirectly, give, accept or knowingly carry a challenge to any person or persons to fight in single combat, with a citizen of this state, with a deadly weapon either in or out of the state, shall be deprived of the right to hold any office of honor or profit in this Commonwealth. And if said acts, or any of them, be committed within this state, the person or persons so committing them shall be further punished in such manner as the General Assembly may prescribe by law. The Third Constitution carried a similar provision, which was put there to discourage dueling. Detractors of this provision, as they had in the previous convention, argued that the Code Duello should not be the subject of constitutional scorn because it actually saved lives by means of its mechanism for the possible nonviolent settlement of affairs of honor. In the only appellate decision concerning this section, the Kentucky Court of Appeals ruled in 1909 that there was no challenge to a duel when one drunken man pulled a gun on another and declared, "God damn you, you start to draw a gun this morning, now, God damn you, shoot," in Ward v. Commonwealth, 1909. Pursuant to Section 239, the General Assembly has provided by statute that conviction for sending, accepting, or knowingly carrying a challenge to duel forfeits public office and disqualifies from holding such office. The Special Commission on Constitutional Review of 1987 recommended repeal of Section 239.
Section 240. Pardon of person convicted of dueling. The governor shall have power, after 5 years from the time of the offense, to pardon any person who shall have participated in a duel as principal, second or otherwise, and to restore him to all the rights, privileges and immunities to which he was entitled before such participation. Upon presentation of such pardon, the oath prescribed in Section 228 shall be varied to suit the case. The Third Constitution contains a similar provision. An opponent of this provision pointed out that in effect it penalizes duelists more than murderers or other felons, who, pursuant to Section 150, can be pardoned and have their right to hold office restored by the governor any time after conviction. Duelists, however, must wait 5 years to be eligible for a pardon that carries a restoration of the right to hold office. There have been no published decisions concerning Section 240. The Special Commission on Constitutional Review of 1987 recommended its repeal.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book The Kentucky State Constitution by Robert M. Ireland, Oxford University Press.